So I recently did a moot court, and this wasn't my first time doing one in constitutional law. So basically, this means that this was my second moot court, and the first time I participated,
I was barely 3 months into law school.
at that point, I thought I understood what mooting actually was. I'd read the Bare Act, I read every section, I read every judgments, I prepared arguments beforehand, and I genuinely believed that I was ready to stand in front of the judges to defend a position. But sadly enough, I didn't understand how mooting actually works. So let's talk about my first attempt, which was when I say I didn't understand what mooting was, I didn't mean I didn't understand what the case was. I didn't understand the structure of a moot court. So basically, I knew the provisions. I didn't know how to build an argument properly. I knew the case name, I knew the names of the parties, I knew the facts of the case. I studied some, I learned some provisions, I learned some sections, but I didn't know how to frame issues strategically, how to control time while speaking, how to anticipate judicial interruptions. I didn't even know the judges interrupt or maintain courtroom etiquette properly. I didn't know about all that. I was just like, okay, the judges will come and I will speak my points. I literally made a ChatGPT generated script and that's it. But the real thing happens when the judges actually start questioning you. They start grilling you, and that's when you understand that knowing the law and applying the law is basically two different sides of the coin. Like those two are literally two different skill sets. Like judges do tend to ask hypotheticals. So when they did that during my first time, I would either repeat my argument again and again or try to adjust mid-sentence without any clarity. And there was no precision, there was no flow, there was no control over what I was speaking. And at that time, I didn't even fully understand why this is happening to me. So I noticed a big shift this time. So this time it was again constitutional law. The previous time it was about reasonable restrictions on freedom of speech, and this time it was a minority community which was a majority in the national level asking for minority rights in the 3 states where they were actually a minority. Now that was more difficult than the previous one. But my preparation this time was completely different, and although I couldn't go much further into the rounds, I actually went to the quarterfinals, so I received the certificate of merit. Last time it was certificate of participation only, and I was really sad about that. So what changed this time? So this time, instead of reading the judgments properly, I broke them down into what was the ratio, what was the constitutional principle involved, where can it be distinguished, and how can the opposing counsel attack this? So the shift was, I didn't just prepare for arguments this time, I prepared responses to possible attacks that can be thrown on me by the judges or the opposing counsel. So one story. So basically this was a special leave petition. They filed for an appeal to the major Supreme Court bench. So basically the Supreme Court has already heard the case and sent it to a larger bench for decision. So when we were the petitioners, like there are 2 preliminary rounds in a moot court. So in the preliminary round 1, we were the petitioners and our respondents who are supposed to argue the law. We are supposed to argue the facts along with the law, and they are supposed to protect the law. And what they do is, when we say that this case is maintainable in the Supreme Court of India, they say that this case is not maintainable, and that's where we won. We won the preliminary round 1. We got better marks. Obviously we will, because they literally quashed the maintainability of the suit. And that's when I realized that just keeping a focus on my own memorials was not enough, and that I had to look at the other side too, the other party too, to find their mistakes and point them at the speaking rounds. And honestly, this wouldn't be possible without my 2 amazing teammates. Like, I divided the issues into the first ones I took, and the last one and the prayer, which my speaker 2 did, and my researcher did a very good job on the research part and the case law finding part. Just like my arguments had an order, I also focused on clarity while speaking. I didn't focus on speed. I asked for extra time from the judges, and they actually gave me. So yeah, you don't need to focus on the speed. No drama, no nothing. Clarity. Speak with clarities. Know what you're speaking. Know what you're about to speak. When the judges ask you questions, listen to them properly. Like, I got crazy hypotheticals thrown on me, which literally played with the wires of my brain. And I was like, whoa, I didn't know moot courts work like this. And about preliminary round 2, where I was the respondent's counsel, which means my role wasn't to create a fresh constitutional theory. My role was to defend state action, to justify it, to make it appear constitutionally reasonable. That requires calm reasoning and not aggressive speaking. So, what I focused on was justifying restrictions, explaining proportionality, defending legislative competence, and showing constitutional balance. Now, the results. Preliminary round 2 got me 96 marks in the speaking rounds. That was significantly higher than my first attempt, and that was the highest marks someone could get in a preliminary round. I qualified to the quarterfinals. The difference wasn't confidence, it was preparation with direction. Now you might be thinking that 96 is a lot of marks. You might get the best speaker award, but that was a near miss. I was very close to the best speaker position. However, in preliminary round 1, my speaking marks wasn't that good as preliminary round 2. I got 96, whereas in round 1 I got 78 because, no, maybe it was 68, I don't remember properly. Because I got stuck, I fumbled because it was my second time speaking. Like the first time I messed up extremely bad, and this time I had a nervousness that no, I am gonna mess this up. And the second time when I actually won, when I actually progressed the first time, I was like, yeah, I can do this. So preliminary round 2 was like I was much more confident, but in round 1 I wasn't. So that made me lose some marks and I didn't get the best speaker award. So this showed me something important. So even if your research is strong, delivery matters. In mooting, evaluation is divided into content, structure, response handling, speaking, and courtroom etiquette. You need to be extremely well in all these. And the best and the worst part, you cannot compensate for one category with another completely. That round made the difference. So what changed between the first and second moot wasn't intelligence, it was understanding the system. The first time I thought preparation meant reading more. The second time I knew that preparation meant thinking strategically and understanding what judges actually want from you. And that mooting is about performance plus law, not just law, and precision wins over noise. Now, where it did hurt was that I couldn't go to semi-final rounds because of a few marks. Like, I lost a few marks, and that actually stayed with me. Because this time I knew that my arguments weren't weak. The position was. Actually, the respondent position had more weight, much more weight than the petitioner one. Like the petitioners are relying completely on facts and a hypothetical situation that the majority can claim minority where they are minority. But that will make a lot of majority people, like a lot of minorities actually claiming that wherever we go, we will be minorities there. So basically, the respondents were heavier. The judgments, the precedents, they all favored the respondents. I did it myself, but the position didn't favor me and I stayed into the quarterfinal rounds and I couldn't qualify. And the difference between qualifying further and stopping was literally just a few marks. So that hurt me, not emotionally, not dramatically. It actually hurt my ego because I knew I had prepared. I knew my content was strong, but I didn't know that my position would play such a great role that the judges would prefer the opposition counsels more than me. And that was when I realized something. That I don't just want to participate in moot courts or debates. I want to dominate them. So next time, it's not just about knowing the law. It's about owning the room. So yes, I went from being eliminated in prelims to scoring 96 and reaching quarterfinals in the same subject, which was constitutional law. And for me, that difference represents growth. And I'm going to keep documenting my life because I love it. Even if I win, even if I don't win, that doesn't matter. I'll keep participating and I'll keep documenting my journey here. And if you want to stay with me throughout that process, you know where the button is.